Hello everyone, my name is Toby Charney, and today we'll be discussing the R.V. Marshall landmark case of 1999 as a conduit for guiding Indigenous policy, specifically on the front of fishing rights in Atlantic Canada. While R.V. Marshall is a legal case, it really has had a very profound impact on policies surrounding Indigenous fishing rights, particularly in Atlantic Canada, and the most substantial impact it's had is the front of treaty interpretation in the context of those fishing rights. At fundamental issue with the R.V. Marshall decision was that of the validity of treaties governing Indigenous peoples for fishing use, and more broadly resource use altogether. In the Supreme Court's case brief, Donald Marshall Jr., a Mi'kmaq fisher, was charged for fishing eel using an illegal net in the closed season in Nova Scotia in 1993, and there were three stipulations violated in the Fisheries Act and Maritime Provinces Regulation. Now, these are acts which govern commercial fishing. However, Marshall argued that Indigenous communities are governed by context-specific treaties, and these stipulate conditions regarding resource usage. In the case of the Mi'kmaq, these are the Peace and Friendship Treaties signed in 1760 and 61, which stipulate that Indigenous peoples are entitled to fish for a moderate livelihood. However, the concept of a moderate livelihood had not yet been defined, and so there wasn't really a strong legal basis for this case. However, stronger policy discourse between various levels of the courts would eventually lead to Marshall's conviction being overturned. And the overturning of Marshall's conviction opened up a series of important policy questions on the front of Indigenous policy. And these questions are outlined in Alex Cameron's book, Power Without Law. The first question is whether or not the terms of conditions of treaties can override provincial legislation and what magnitude of overriding these can take in effect. The second question is whether or not the requirements established in treaties can be modified based on contextual changes over time. Because moderate livelihood might have looked very different in 1760 compared to 1999 and now in 2023, it was important to understand how treaties can be reevaluated in the present context. And a third question is whether oral agreements hold equal legal weight to that of written treaties, because many Indigenous communities have and continue to rely on oral agreements for treaty processes. When considering the agenda-setting process of the R.V. Marshall decision and the subsequent policy, there are a series of important precedents and contentious issues that helped pave the way for this decision. The first are the interaction of the Peace and Friendship Treaties of 1760-61 and the Canadian Charter of Rights and Freedoms, which arrived in 1982. Section 35 of the Charter affirms the existence of treaty rights as valid and legally binding processes to govern Indigenous resource and rights-based usage. And the Peace and Friendship Treaties stipulated that Indigenous fishers in the Maritimes, namely the Mi'kmaq, were entitled to fish for a moderate livelihood. The parameters surrounding this were very context-specific, and creating greater clarity how those modern fishing rights could look was a big part of the discussion in the initial decision of Marshall. There were also a series of landmark cases that had taken place decades prior, namely R.V. Sillyboy, R.V. Isaac, R.V. Simon, and R.V. Sparrow, between Indigenous fishers in Atlantic Canada with the Crown, and these helped pave the way to argue that this treaty should be the governing basis for Indigenous fishers. And of course, Marshall's initial conviction in 1993 set the stage for the decision, which took place later in 1999. When considering the policy formulation stage, the Supreme Court decision is ultimately what allowed the formulation to begin, and this is what granted the federal and provincial governments a greater basis upon which policy could be evaluated. So modern treaty interpretation must reflect the common intentions of both parties was the first major stipulation of the court decision. A second stipulation was that oral agreements are deemed an integral component of the treaty process. And third, fishing rights are held by the community rather than by individual members of the community. And this is important to note because it allowed individual communities and collective communities across the eastern parts of Canada to be included in Marshall policy and initiatives moving forward. At the policy adoption stage, the response initiatives enacted largely by Fisheries and Oceans Canada have been a prominent manifestation of this part of the policy process in the post-Marshall decision context. So the Marshall Response Initiative, enacted in 1999 until 2007, was kind of the first wave of responses, and the agreement essentially reached with 32 eligible First Nations communities across eastern Canada, and it aimed to provide commercial licenses and infrastructure, which was then aimed to support the socioeconomic integration of Indigenous fishers. Because a big part of the process of the Harvey Marshall decision was aiming to bridge that gap between Indigenous and non-Indigenous fishers and providing Indigenous fishers with their guaranteed treaty rights. And following that decision expired in 2007, the Atlantic Integrated Commercial Fisheries Initiative began, which is still in effect, and this aimed to expand support to three broad general kind of sectors of Eastern Canadian Indigenous fishers, namely the Mi'kmaq, the Maliseet, and the Pescatawamukasi First Nations. At the policy implementation stage, there was changes to provincial legislation across eastern Canada, and these were made gradually in the post-Marshall era, specifically in the 2000s. So the concept of fishing for a moderate livelihood became a legally enshrined term governing Indigenous peoples, and these were stipulated by treaty rights as opposed to by federal and provincial fishing legislation. And these changes were made in Nova Scotia, New Brunswick, Prince Edward Island, Newfoundland, and the Gaspé area of eastern Quebec. When looking at the policy evaluation stage, we see that legal and political changes to federal and provincial legislature, as well as changes in novel policy programs arise, and those were mainly determined through the Fisheries and Oceans Canada Department. The first big legal change to consider is that of the Marshall II decision, and this was made when there was a lot of conflict between Indigenous and non-Indigenous fishers in eastern Canada. They critiqued that Harvey Marshall wasn't clear in stipulating what constitutes moderate livelihood and what limits of treaty rights can be justified based on the individual actions of fishers. And so the court clarified its position by stating that the provinces could regulate Indigenous fishing actions based on two core concepts. The first being conservation concerns, the second being important public objectives. As will be discussed, these are pretty vague terms and are a big drawback of the Marshall policy. A second manifestation of policy evaluation came with the form of rights reconciliation agreements, which is a novel policy offshoot developed from Marshall in 2017 and is continuing into the present day. So these are specialized agreements that aim to start dialogue between First Nations and government officials in negotiating what a moderate livelihood fishery looks like. And it's largely rooted in the duty to consult, and this is a very long-standing tradition of Indigenous policy in contemporary Canada. So these are some manifestations of policy evaluation in the context of the Harvey Marshall decisions. When considering decision makers for the Harvey Marshall decision, there are three broad actor categories that are identified in Michael Michel's dissertation investigating this case study. The first are those of Indigenous actors, which argued that the Peace and Friendship Treaties of 1760 be the dominant governing bodies for Indigenous fishers. And some actors to note are Donald Marshall Jr., the accused, Native Council of Nova Scotia, as well as the Union of New Brunswick Indians. A second body of actors to consider are those of legal and governmental actors which were responsible for deciding the decision and upholding and promoting legislation in the wake of the Marshall decision. So those include the Nova Scotia Court of Appeal and the Supreme Court of Canada for making the decision, and Fisheries and Oceans Canada, as well as various provincial governments for updating legislation to make this policy sound for Indigenous peoples and fishers in Atlantic Canada. A third body of actors to consider are those of non-Indigenous actors, specifically non-Indigenous fishermen, such as the West Nova Fishermen's Coalition, which have been largely responsible for pushback against the Marshall decision, arguing that a more uniform policy should be applied to Indigenous and non-Indigenous fishers alike in the Maritime Provinces and Atlantic Canada. Evaluating the application of Marshall policy really does require an evaluation of the three main goals of the Harvey Marshall decisions, and these are again outlined in Alex Cameron's book, Power Without Law. The first goal was to secure moderate livelihood for Indigenous fisheries. The second, to ensure that treaty rights reflect modern socioeconomic needs of Indigenous peoples and are up to date and able to change with the times. The third is the respecting of an equal weight and validity of Indigenous-led agreements, such as oral agreements, in a contemporary context. The first goal of obtaining a moderate livelihood for Indigenous fishers has not panned out entirely, and this has revealed an inefficiency in the Marshall Policy. So, the definition of a moderate livelihood is largely determined through agreements between specific nations and provincial governments, and these have been very, very slow to pan out, and there is yet to be federal recognition or definition of this term. There has been an increase in commercial landings amongst Indigenous peoples as a result of the various initiatives established by Fisheries and Oceans Canada. For example, there has been an increase in communal commercial landings from 3 million in 1999 to 140 million in 2018, which is an impressive increase. However, reporting from Trina Roche and interviewing of Indigenous fishers from the Atlantic provinces reveals that the proportion of Indigenous profits remain grossly underrepresented, namely less than 5% as of 2016, which indicates that there's still a socioeconomic exclusion of Indigenous fishers in the post-Marshall era. The second goal of modernizing treaties to reflect present-day socioeconomic conditions has also technically been materialized since the Marshall decisions, but has been slow and inefficient, as uncovered by Nicole Johnson from Cape Breton University. It's taken 17 years between the initial Marshall decision and the first rights agreement to materialize, and since then, only 3 have actually been formalized between provinces and Indigenous nations, namely in the Quebec-Gaspé area and select areas of New Brunswick. So if Indigenous communities, the 30-plus Indigenous communities that have actually been included in the Marshall initiatives are to actually obtain clarification as to what that moderate livelihood rights fishery would look like, it's been very slow and inefficient. The third goal of the Marshall Policy, namely to recognize Indigenous-led agreements, such as oral agreements, as equal and important parts of the treaty process, has been successful in the initial stages of the Marshall decision, namely because the Marshall case was largely made possible through recognizing oral agreements at the Peace and Friendship Treaty signing, and this was hugely monumental for Indigenous communities, and it has given them a new sense of legitimacy on the front of policy negotiation. However, there hasn't been a lot of change materialized in the long term. In other sectors of rights governance in Atlantic Canada and across Canada, oral agreements remain underrepresented and not understood. And to really make this goal materialize, there needs to be more rights reconciliation agreements moving forward. As stated, only 3 have been finalized thus far, and progress is looking very slow on that front. However, RV Marshall Policy has several limits, and it's adversely impacted largely the socioeconomic liberties of Indigenous fishers, and it's created lots of rifts between Indigenous and non-Indigenous fishers as a result. Pamela Palmater, who wrote An Empty Shell of a Treaty Promise, documents some of the limitations quite eloquently. One of the biggest limitations noted is the socioeconomic isolation of moderate livelihood fisheries. Because the fisheries created through the Marshall Decision are rooted in treaty rights and not rooted in contemporary commercial rights, there is a separation of many Indigenous communities from the wider fishing system, which is part of the reason why there's been a disproportionate underrepresentation of fishers amongst profit shares in fishing stocks in recent years. There's also been an unclear parameter surrounding Indigenous participation in commercial fishing, and this largely stems from the fact that the RV Marshall decision never considered commercial fishing. It only considered moderate livelihood, as is stipulated in the Peace and Friendship Treaty. However, the quest to move forward on the front of commercial fishing rights is something Indigenous communities are looking to do more so, and because the Marshall decisions didn't clarify that, there's been some pushback and some confusion. A third limitation to consider is the separation of traditional fishing from customary fishing, and this is a very deep-rooted issue, not just in RV Marshall, but in fishing policy altogether in Atlantic Canada, because in the effort to indicate traditional fishing is in this category and commercial fishing is in another category, Indigenous communities have a hard time integrating by the nature of the policy framework, and RV Marshall has not been effective at mitigating that policy divide. With over 20 years having passed since the RV Marshall decision in 1999, tensions between Indigenous and non-Indigenous fishers remain very high, and this largely stems from the fact that commercial fishing and customary fishing remain separate. A big demand from Indigenous fishers moving forward is to create a third fishery category, one that combines treaty rights with the commercial fishing sector in such a way that Indigenous and non-Indigenous fishers are partners as opposed to rivals. The Marshall policy alone has not been substantial in bridging this divide, but we can hope that future landmark cases and comprehensive conversations and discourse between various actors in the fishing sector of Atlantic Canada can help resolve this policy divide. What can be said regardless is that R.V. Marshall opened up a very important conversation on the front of treaty rights recognition, not only for Atlantic fishers amongst Indigenous people, but also for Indigenous people across Canada as they strive to balance their treaty rights with contemporary policy frameworks.